What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. For everyone who was involved in Members Monday last night, had a lot of fun. Thank you so much for everyone being on the panel and for all the members. So much fun. So much fun. Anyways, on to tonight. I've got, well, semi-conclusion to a case we've been following for a while. You guys know Attorney Taupe. She's the one who is in front of Judge Simpson, kind of got forcibly removed from a case and kept filing. So now she's in front of him for potential contempt charges, a show cause hearing. But we got to get through the eviction case first. They do address the Ms. Taupe at the end of the eviction case. Not the eviction. Is it an eviction? Yeah, kind of. It's a commercial property. They're evicting horses, but it's still kind of a landlord-tenant case. I think the rules kind of are different because it's a commercial property. Anyways, doesn't matter. We're gonna watch it. It's gonna be fun. So yeah, I did have to pull a quick switch on my video tonight. I wasn't gonna play this at first, and then I was like, you know what? There's a lot of people asking for it, so let's just do it. Let's do it. We can watch the semi-conclusion. That'll make more sense here shortly. Why it's not the final nail in the coffin. They have one more appearance, but Judge Simpson rules on everything today, so it's a semi-conclusion, and we get an update from Ms. Taupe, or for Ms. Taupe. Yeah. Anyways, a real quick update on the GoFundMe for Muse. We are, or Muse, or it doesn't, yeah, whatever. I don't know. We're $147 short of the goal. $147. So tonight will be hopefully the last night I post a link because I think we can make $147 tonight. That being said, yeah, I feel like I'm just going to cover it. If we don't make it tonight, I'm just going to cover the rest. So, $147. We got this, guys. We can do it. We're gonna hit the goal. We're gonna hit the goal. 147, and then Muse. You know, good luck moving forward with everything. And I hope everything goes well. So, yeah, like I said, I've said this 100 times. We take care of our own. I'm not gonna redo the story. If you want to read about it, they did a great job on the GoFundMe page. Just click the link that's pinned, and you'll see exactly what's going on. Anyways, on to Judge Simpson. You guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Court does call the case of Fixing Housing 401k Plan versus Erica Ward et al. Counsel, state your appearance.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k Plan.
Your name?
Good afternoon, Erica Ward and Aaron Ward, on behalf of ourselves.
All right. All right.
Your Honor, I believe my client representative, Mr. Hawk, is participating over Zoom.
Is that?
I think he is on his iPad.
iPad 4, I'll need you to unmute, state your name, and turn on your camera if you're participating in these proceedings.
He did actually post in the chat as Mr. Hawk previously. I can't, I don't know if he's there.
All right. Posted it in chat is there. We'll need to.
Yeah. That was at 2 something.
I'll need visual confirmation.
Hey, Mark. What's up, buddy?
Otherwise, they have to get out of Zoom. All right, this date and time set for a couple of things, but mainly the motions in this case. All right,
Yeah, ready to go. The motions.
you ready to go?
Yeah.
All right, go ahead.
Your Honor, I'm not going to belabor the points that I've been making at multiple hearings. The lease expressly provides that tenants must pay monthly base rent of $5,500 quote, without any deduction or set off whatsoever. That is paragraph 3 of the lease. As the court correctly stated back in November, the lease language is not conditional. That transcript from that hearing is Exhibit E to our motion.
Don't worry about it, Lisa. I appreciate that you're being here, and yeah, it's fine. We've got it. So yeah, but take care of yourself. That's more important, and thank you for hanging out with us.
Your Honor, tenant's sole defense is that the lease is actually residential, is frivolous. Tenants admit in filings with this court and the circuit court that they are operating a commercial horse sporting farm on the property. Tenants don't reside on the property, and it's a business collecting money from the boarders. I quote from their circuit court complaint, this is paragraph 2, Eric conduct her business. Will Award Equestrian LLC allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. This court, again, back in November, acknowledged the commercial nature of this lease dispute. Tenants argue that the lease does not use the word commercial. It does not use the word residential. It is a 7-year lease ending April 2028. Paragraphs 4 and paragraph 8B of the lease supports that it's a commercial lease. In the circuit court, tenants individually are bringing a business interruption/tortious interference claim against landlord, seeking alleged lost profit damages. So tenants are seeking alleged damages to their business on the property under the lease in the circuit court, while conversely arguing that the lease is residential in this court. Tenants signed a lease and guarantee. Landlord brought a breach of guarantee claim in circuit court. The separate guarantee agreement further evidences the commercial dispute.
Where is it dates? Go ahead.
Your Honor, Michigan case law provides that tenants may not withhold rent for repairs in commercial context. And I've cited these cases many times, the Rayum case and the Detroit Marine Terminals case. They provide in a commercial setting like this, the landlord's covenant to repair is independent of the tenant's duty to pay rent. Thus, any money claim for breach of the landlord's covenant cannot be set off from the rent that is due, and that's from the Detroit Marine Terminals case. Your Honor, I know that tenants have filed additional filings yesterday. I believe they also help my case.
Did we receive documents yesterday?
Yes,
I simply filed an account.
On the front, got it. Okay, I see those. Okay, go ahead.
Your Honor, I just give you context. I received an email from Ms. Ward sending me pictures of the pages of these filings last night at 7 o'clock, and just received copies of these filings in this courtroom today. They reattach Ms. Tope's affidavit, which was the reason for the show cause hearing. I can dig into the substance of Ms. Tope's affidavit, but none of that changes that the lease says what the lease says. And they did not have the right to withhold rent. And actually, there are paragraphs in the affidavit that support my position. If you want me to go through those, I can.
No, yeah, I don't know that that would be necessary, quite frankly. But go ahead.
Your Honor, and their only defense is that this is actually a residential lease. There are no grounds for that. Please grant our landlord's MSD. Thank you.
Your Honor, actually, that is not the case. The past 2 weeks, based on review, we fully understand that the lease has been deemed a commercial lease, and that under a commercial lease, you cannot withhold rent. However, we believe our motion for dismissal with prejudice should be heard, and that their entire basis for their summary disposition or the request for summary disposition is based off of a retaliatory lease, based off the fact, and I have emails.
Retaliatory lease.
A retaliatory eviction. He sent me an eviction notice within 7 days of replacing the water heater, which, Your Honor, he continuously says that we made a unilateral decision to replace the water heater when I have documentation, which unfortunately I just thought of showing you this and I can't because I didn't submit it. But he knew about the water heater. He told us to have someone come out. We had the professional come out and we submitted our June payment of $2,800 after fixing this, because the professionals told us this is a 30-year-old water heater. There's a gas leak, it's toxic and it's dangerous. So there is a statute under MCL 65720 that states.
Felix, I don't, this is words are hard. So I just signed a new lease, I don't know, 2 months ago. And my landlord agreed not to increase the rent if I signed the lease within, I think they gave me 2 days, within 48 hours. And if I didn't sign it, then they were going to give me the statutory increase in rent. So yeah, I was just like, wait, what? Like, I mean, 48 hours is plenty of time to read through the document, but I was sitting there, I was like, wait a second. All right. I mean, I don't want my rent increased and I wasn't planning on moving, so I'll sign it. But it was just the fact that they said that to me. It's like, all right, I've been here for 5 years. You're going to give me this. Okay, let's go. Here you go.
They cannot evict me within 90 days of me going to them requesting things that are, as he stated, the lease says what the lease says.
Yeah, statutory wasn't the right word. I don't remember how they worded it, but they were going to give me whatever the percentage of increase was. They haven't increased my rent at all. I've paid the exact same amount since I got here, but this was the first time they've ever mentioned on raising it if I didn't sign it within 48 hours. It blew my mind. I was also in Canada at the time. They knew I was in Canada, so they were probably like, he's not coming back, so let's try to force his hand. That's what I assume happened. I don't know.
Regardless of whether it's a commercial lease
Well,
or residential
but
lease.
you're quoting the retaliatory eviction statute.
Yes. Because their whole case, they're requesting summary disposition based off of a case that an illegal case that they're bringing against us. Because it was June 1st or 2nd that we notified them.
Ma'am, read that statute and tell me the language in that statute that you believe is applicable to this circumstance.
If the landlord started the eviction proceeding within 90 days after we, the tenants, tried to enforce our rights against the landlord who did not respond to fix a dangerous, toxic, fire hazard gas leak in the residence of the property in June, I informed the landlord of the hot water tank that it had not worked and that.
Slow down. So
Okay.
You're saying you informed him of it.
And he told us.
But he told you to repair it,
Pardon?
right? He gave you permission to repair it, you're saying.
He gave us permission to have a professional out.
Okay. And
that did
that,
nothing.
but what did nothing?
And then no more communication until the 13th when I got emails telling me that he was replacing me, the bar manager. I couldn't collect my board anymore and all kinds of other craziness. Best way I can describe it. On the 13th. And so that is when I got a lawyer and I filed suit in circuit court against him on July 9th for breach of lease for many.
So you think that the reason that they're here in this case is because why? Because you sought to enforce your rights?
Yes, it's a retaliatory eviction, absolutely.
But I think you need to look at the retaliatory eviction statute a little bit closer and look at the cases under it. I don't see this as a retaliatory eviction case at all.
Okay, so I'm sorry, but I haven't really heard was that his motion for summary disposition that that's the same thing I've heard. Is that what he's?
Yeah, I mean, he's basically saying the lease says you can't withhold.
Absolutely, and that's fine. And if you were to grant summary judgment, then we would absolutely pay back the back rent minus, this is why I submitted this account.
No, but minus what?
Well, the things that he's responsible for in 6A and B of the lease. I've been asking him for years, since 2022. At a minimum, there's enough information to do discovery and have it heard before a jury.
I think jury at this point in this case at least is waived, so I don't think
Or
that's gonna happen.
a trial.
Well, you can have a trial maybe. But basically, ma'am, these are counterclaims for for payment under other provisions in the lease.
Correct, 6A and B, where it states that he needs to do this and respond within 48 hours.
Okay, but the bottom line is you would still owe the money, but you're saying that there are offsets or money that he owes you.
Correct. And it might, like you said, the law is the law. And Your Honor, but there's also justice. And so I don't believe that I breached the lease because I'm willing to pay back the back rent. I mean, I've been paying into an escrow, which I understand that was a wrong process. So that put us in a bad spot. So moving forward, we've put it in escrow with the court, as you, Your Honor, told us to do. We've never not paid rent.
Okay. Anything else you want to tell me?
Well, again, I guess I'm just asking you to consider that if we have to pay the rent that went towards repairs, which basically is investing in his property, yes, I would ask that you would.
Well, but you
consider-
don't, hang on a second. Let me ask you this, Ms. Ward. There would be a difference between you paying rent, right? I mean, sometimes the way that these things end up in litigation is if you had paid all of your rent, but then these repairs weren't done, what would you have done?
Well, now I understand what I should have done.
Is
file-
what?
Pardon me?
Is what?
Is filed a lawsuit against him and had you direct how to spend the money. Correct.
Well, I could have done that if it got to that point, or I could direct repairs be
Right.
made, or whatever.
Right. I understand
Okay.
that.
So in essence, what you have here is a counterclaim for these things.
That's what I'm asking you to consider. Yes, Your Honor, but obviously that's in your hand.
Yeah.
I know, I say the obvious.
But in terms of the crux of their motion, that they're entitled to their rent without set off, you would agree with that? If you look
Based
at,
on the law and the research that I've gone out and done on my own since I dismissed my lawyer, or she withheld, whatever you call it, then yes, I personally still think it's
so,
great.
so then tell me, just tell me this. Tell me any reason you believe I should not grant their motion for summary disposition as to liability.
Can you say that in another way? Because I know summary disposition, what do you mean as to liability?
Meaning,
Whether or not.
I make the legal determination that they're right, that they're entitled to their rent without any set-offs. Now, that may not resolve what are your counterclaims.
Because without any set-offs was not even in the lease. So without any set-offs was in a separate document, which was a guarantee, which I also think is, if not illegal, definitely shady, telling me, okay, I'm not a commercial person. I mean, I had a friend who's not even a landlord tenant lawyer review this for me before I signed it. Okay, that's my fault. But he had me sign a guarantee, completely not even in the lease, that says no set-offs. The no set-offs, as far as I read in the lease, and what I was going to was section 6A and B.
I don't think she's an internet lawyer. I think that she is still being quietly represented by Miss Tope. And yeah, that's what I feel. Because she gets better and better. She gets better at this every time she appears. And I just, I mean, that just could be experience. Maybe she's just leveling up. I don't know. But I feel like she's still being told what to say.
So I didn't know what else to do when this landlord is refusing to do anything, to repair anything. And I have all the documentation asking him about it for well over, since 21, actually. So no setbacks is not even in the lease. I guess that would be what my contention would be.
So are you saying then that you have the right to set off?
I'm saying you have the jurisdiction to make a decision, but yes, I do think it's gray. I think the whole thing is very suspect. I mean, we did, obviously that we filed a breach of lease on July 9th. And then it was in October, he's evicting me, and I paid the full.
July 9th in circuit court.
I filed in circuit court.
Right.
Yes, a breach of lease for all of the stuff that he's done.
And you're saying that because of your filing, this is retaliatory?
Well, it's retaliatory based on the first time that I spent my rent money on having this fixed, which he told me to have professionals come out and look at.
But
hold
on a second. That isn't retaliatory.
Well, he told me to have the furnace the water heater looked at.
Correct.
I got it fixed, and then 7 days
Well,
later.
but hold on. Did he tell you to have it fixed?
Let me know what they say. And when a professional comes out and says it's.
Okay, hold on a second. So he tells you to have the furnace looked at and let me know what they say. So hold on. So did you then let him know what they said?
I paid while they were out there because they said to do it immediately.
So that's a no.
But he had established a process over the years. It's a no, Your Honor, correct. You are right. It's a no. But over the years, he had me hire, he finally, after months of asking him, I got an electrician out. He refused to pay the electrician. And we even said in the email.
But you have to slow down. You're jumping around.
No, my heart rate's at like 140.
So but you keep talking about this retaliatory nature of things. And what I don't see this as a retaliatory eviction.
Okay, then I'm not a lawyer, but for whatever reason, I've always paid my rent. He has set a precedence of saying, yes, fix this, go ahead, keep it out of your rent. I have done it 3, 4, 5 different times over since 2021. I'm not a commercial entity, regardless of the stupidity.
Okay, but here's the thing. If for a particular portion, you're saying that there are previous times where that's occurred. And those previous times, right? There was, in essence, an agreement in writing to deviate.
That's true.
Right?
After months of
Okay,
saying,
okay.
Correct.
So that both parties at that point agree that we're going to pay this, and then this is the amount of the rent we're going to send you. Right?
Let me confer. Yeah, that's true. He did not ever, he never sent a text that said, go ahead and take it off. There's multiple times it's happened. On occasion, he said, fine, Other times, he just ignored us. He ignored me for months at a time.
Okay,
And then
he
so
ignores
we
you,
pay
but
it-
what do you mean by he ignores you?
Can Aaron comment or am I?
I don't care who,
Okay.
he's part of this case too.
My wife is following an established process. We had a verdicts go out.
Okay,
And have someone come out and fix it. We did. The plaintiff refused to pay him. I sent him several messages. I called him saying, please pay the person who deserves to get paid, or I will take this out of your lease. I never heard from the plaintiff. We took it out of lease.
and hold on a second. And what did he do because you took it out?
Nothing.
Right,
It's happened 3 separate.
so now on this occasion, right? Did he tell you to fix those things?
No, Your Honor, but that's.
So hold on,
No,
because you're gonna have you've got a very different circumstance.
I believe we were just following the process that they established where things got fixed. We took it out of lease. Gas leak. I understand what you're saying completely, Your Honor.
It was a gas leak. I thought it was an emergency repair.
The process had been, it gets fixed, we take out lease, it happened to be.
Well, that's the process where he says, fix it, have it fixed. Then the person you're saying is not paid, it doesn't matter to me about that necessarily. But at some point, you then take it out of the payment you're sending him because you've done it. But at the crux of that is him saying repair it. What we're talking about now, that didn't happen. That first part, right?
Correct.
You were just saying, I have a problem. He doesn't respond, may not respond, doesn't do anything, or says, have somebody come out and look at it and let me know. You then decide to sort of jump ahead, you repair it and then take it out. And what I'm indicating to you is, I don't think you could do that. The party certainly can deviate. If it were an established practice that you would just make any repairs that you thought necessary and then send him the balance, and that's the way it went, that'd be one thing. But that's not what this is. The distinction is, he says, because he has an obligation to make some of those repairs, he then says, just get it fixed. And then ultimately you take that out. And I think rightfully so, then when he said fix it, he doesn't complain about what she did. But it's when you do it differently that there's going to be the complaint.
I
No.
can't argue with you there.
You can argue with me how you want.
Well, you wouldn't listen anyway, but I know, I get it. I understand. You shouldn't.
We're in a tough situation, we had gas leak.
I
Unfortunately, people
thought-
know the plaintiff not paid, so we have someone who knows the plaintiff's not going to pay, we need to get it fixed, and we thought we were following the process. I understand this stubbornness. It's very,
I don't think it justifies an eviction, and he wants the $2,800.
Well, and it may not, because understand that although this is a termination, I'm not clear that termination is necessarily going to be the result.
Well, that would be great.
Well, I don't know. I haven't made a decision. I haven't heard it. The issue on their motion for summary disposition, I think it's the liability for the rent, liability for the breach. Yeah, but I can just certainly decide on the remedy, which is why I was trying to get to the parties to have them understand that I really think the parties need to resolve this.
I felt we made a very fair settlement offer.
Well, I don't want to get into that, but I really do think it should be. So as to the issue of rent and liability for breach of the lease, but not as to damages and remedy, I'm going to grant the motion for summary disposition. as to the amount of damages and as to the remedy to be applied as being a summary proceeding, the court will make a later determination on that.
Say that one more time, maybe dumb it down a little. I got that you found in
They
favor.
win on, yes, I find in favor that the lease is interpreted in the fashion that plaintiff wishes it interpreted, and that is that you're not entitled to an offset for monthly rent. It still doesn't resolve the issue, and I don't know that we've gotten that far as to the issue of what repairs needed to be done, but they're not going to face liability for repairs that you made without their approval. That's probably going to be the practical effect for you. Got that? You're looking at me like you didn't understand what I just said, but I'm more than happy to explain what I'm doing, but.
Oh.
You got it?
Yes.
Okay.
Your Honor, there's many things I'd like to respond to, but the breach of the lease is the grounds for the termination.
I understand that.
And that's why we're here to evict them. Your Honor, regarding any counterclaims, they have not pleaded any counterclaims. They filed an answer. They didn't file affirmative defenses. They didn't file counterclaims. That was when they had assistance of counsel. So any alleged counterclaims that they have should be deemed waived. And it's also the same thing why they rushed to court and filed in circuit. So I don't think there are any questions of fact as regarding their damages. They're trying to seek damages through motion practice.
I understand that. I understand what you're saying, but you're also requesting a money judgment along with just termination. You're not just seeking possession. Right?
Yeah, we're obviously asking for the money that's owed.
And what I'm saying is, I'm granting it as to liability that there's been a breach. The court possesses a great deal of latitude with what the effect of that breach will be, and as to the issue of liability. And I think the issue of liability, well, the issue of damages, which still would have to be decided by this court, may be up in the air. If there were repairs that needed to be made, it wouldn't be an offset on rent. They may have breached in that regard, but they may still be entitled to certain repairs which weren't done that they did from a monetary standpoint, not from a breach of the lease standpoint.
I understand that, Your Honor, but they would be off of counterclaims that they have not.
You can make that argument. I mean, but we still have to have damages here. So, because I haven't ordered damages. So there'll be a damages here. All right.
Would the court entertain releasing any of the escrow because they have defaulted on the lease?
I think that if the parties, I would strongly consider it. If I felt there were good faith opportunity or good faith to try to resolve that portion of the matter. I mean, and I'll just put it this way. I think there was a timing of move out that, and I'll be blunt about it. A timing of move out to move livestock during the winter is cruel. It can be done, but there are a lot of effort. Livestock have to be moved to a different location. Then it's really best done in the spring. Or, well, really summer's not a great time to necessarily do that either. But I think the parties are certainly at a point that it really is an issue of move out. Paying and then moving out. And it's just an issue of timing. As far as I see it.
I mean, Your Honor, we were the first ones to offer a settlement offer, which was rejected.
And counsel, I'm not saying that you haven't. I'm just saying it's really an issue of timing. I think they're gonna be better off being someplace else. I think your client's gonna be better off having that property. It's just how many horses do you have there?
38.
38. It's how and what is.
I was waiting to interrupt for us to hear that number. 38 horses. On one hand, it doesn't seem like a lot, but we're talking about horses. Yeah, you have to find a new place for 38 horses. Hopefully, these people have been trying to figure it out during this whole process. I mean, this has been going on for what, probably 3 months now. They've been in and out of court. Hopefully, they've been trying to figure out a resolution that isn't staying there because it's not working. That I just have a bad feeling for some of those horses, though. What are they going to do? Just abandon them? Now remember, they run a business, right? So these aren't their horses. They provide spaces for other people to keep their horses there. So what do? Just tell all their clients like, "Oh, we're going out of business. Come get your horse." You can't really do that either. This is a very tough predicament. I don't know what the solution is here. Maybe this is common in Michigan. I don't know.
There's a proper amount of time to move those 38. That's really the issue as far as I'm concerned. Yes.
If it's possibility that they could buy the business if they want.
That I'm not getting.
I don't even know where all the
I'm not
horses are
getting.
going to go.
All right, there you go. Yeah, she pretty much just admitted to what I was concerned about. She just said they can buy the business. Yeah, you've already admitted that your business isn't profitable. They're not going to buy a business that's not profitable. They don't want to take up horses. Maybe they do it. Maybe they built this to, I don't know. Maybe it's an old farm space that, you know what? I've got a lot of. I'm going on a tangent. Let's just watch the case.
Okay.
I'm not getting into that. I'm saying that if you had to move them, let's put it this way. The court said right now they breached this lease, their tenancy's terminated. I set the writ date. It's not going to be 10 days. And so I would suggest, given the court's ruling, that the parties be reasonable about a reasonable time to vacate the premises. Not too long, not too short. Otherwise, what's going to happen is, if it gets down to that point, I am going to make that decision myself. I don't have a problem making that decision. And it's not going to probably be good for either party. That's my only point. Okay. All right. Counsel, did you, I did not see it, and I don't know if you filed it, a bill.
I did not file it.
Pardon?
I did not file it because there was a moratorium on not filing, which I was following.
Yeah, understood.
I have that here. I think it should be increased because they filed something yesterday.
Yeah.
Which I had to review their pictures and then review the filings today in this courtroom. So I think it's
because this case has been focused on the attorney so much, Attorney Tope. That's why you didn't really know horses were part of this case. People that that have been following along since day one of this case and really been paying attention, they will know that horses were a part of this case. But if you were just here, like, oh, Miss Taupe is a mess and we're all laughing at her, yeah, you kind of lost track of what the case was actually about. So I don't blame you on that. I do it all the time. I'll post a video and I'll just be so excited that someone's yelling at the judge. I don't even remember what the case is about. That is common.
It should be subject to an increase.
Well, here's what I'm gonna do. Hold that because Miss Taupe is not here. And that was gonna be part of the,
All right. That being said, Judge Simpson just talked about Miss Taupe. We're about to get into why she's not here. Now, remember, she was issued a order to show cause. Why she was still filing on behalf of the defendants or the tenants, and yeah, she didn't show up. That's a problem. An an order to show cause in front of a judge, and you don't appear. Ah, it's the worst thing you can do.
I did find my emails if you want them.
your emails.
You wanted to know exactly whether I knew ahead of time or not,
Knew ahead of time of what?
that she filed something. You had asked for them at the last court. I couldn't find them on my phone. I don't know if you want them or not.
Well, did you know?
After the fact.
After.
Yeah, which is what I told you, but you had asked.
No, I
Right, okay,
understand what, I figured that to be the case.
okay,
You told me that. I
Right.
took you at your word for it.
okay,
I believed you,
Good.
which is why I set the show cause,
okay.
because it was filed on your behalf without your knowledge.
Correct.
Okay, that was my point, which is why then I set the show cause in part for Miss Taupe, because she's no longer the attorney of record. Now, in regard to that show cause, and why I'm gonna tell you to hold that, and you may be able to add to it at some point, counsel, but I issued an order to show cause to Miss Taupe on, what date was that? That was on January 20th. I set the hearing for today. Show cause was sent out. The 14 days was given, as best I could see from the file. It was certainly sent out. It was sent down to the clerk's office and mailed out. We then, where's the email? I just want to get the quote.
This is from her, my emails.
Right. Okay. We then get and I'm gonna say this a little bit backwards.
All right, before we go into this, I want to give a quick update on the GoFundMe. We are $87 away. $87 away from Muse's goal. Hopefully we can hit that. There's only 15 minutes left in this video. Got 15 minutes. We got this. We got this. Come on, guys. If you can't donate, you can't donate. I'm gonna cover whatever is not covered by the end of the stream, just so we can finish it, and we can say congratulations to Muse. So let's go.
We didn't get a email from Miss Taupe, and it's entitled 2 p.m. show cause today. And it's addressed to my judicial coordinator. And it says, hello, I have not gotten any notice at my address or email for the show cause D Taupe. You show scheduled for today at 2 p.m. on Judge Simpson's docket. I do not know anything about this. I have not had any contact from the court about it and am unable to attend. That's what she signed, so that I can make the record clear. A notice to show cause was sent by the clerk's office when I'm looking at the file, the process that the court follows, I sign off on the order to show cause, it's sent to the clerk's office and then sent out to the parties. That happened. Additionally, and it's odd that we received the response today, and I'm sure all of you probably would have seen this process in one form or another. But on January 27th, the first version of the docket, which is set for today, would have been sent out by email to the parties. You then get an updated version. I think it's the initials, and the updated version was sent out on January 30th to the parties, which would show it's scheduled. You're looking at the time. Then the day before, because things get moved around and whatever, we send out our final of it. For Ms. Tope to say that she had no notice of it or anything along those lines is just patently false, because I have the emails of those various dates, the 27th, the 30th, and the 2nd, where Ms. Tope is emailed directly at her email address showing this to be scheduled. So it is once again a delay on her part to not show up. I will go further to say that she consistently flaunts this court's orders by, when she's off of a case, filing documents. I don't mind the parties when they want to argue with the court, but the disrespectful manner in which she has argued before this court. Some people show their disrespect in different ways, but it's always noted with Ms. Tope, she is a member of the bar of this state. I do not take lightly issuing show causes against attorneys in the first place. Don't like to do it because usually, because they are officers of the court, I can command them to be before the court at whatever point I want them to be before the court. But her behavior to this court is.
Tara, thank you so much. I don't want to keep this pause long because this is the most exciting part of the video. Thank you for letting me know. Thank you.
For a member of the bar is atrocious. And what I think, at least as I've seen in 2 cases, predicaments which she has put individuals which she alleged to have or was representing is also, from my perspective anyway, atrocious and highly unethical in terms of some of the ways that she's been proceeding. So it is with great dismay, but when an attorney or someone tells me I'm not appearing, I know they've had notice of it and they refuse to come before the court. The court is only left with one other option, which is its ultimate way in which to compel someone to appear. And so I'm going to issue a bench warrant for Ms. Tope's arrest. Her bond in this case, your approximate bill, counsel, what's the approximate amount that you have at this point?
Your Honor, that I have at this point is $6,975.
Good enough. So I will issue a bench warrant. Bond will be set in the amount of $10,000 cash and or surety. That warrant will issue immediately. So that you know what will happen is, and I have a feeling we will catch up with Ms. Tope very quickly. Once that hearing is then set, she is not in custody and hasn't posted bond, we will let counsel, we will let the parties know. At that point, I would like to see the billing.
Okay.
All right.
Yes, sir.
You follow what I'm indicating on that?
Yeah.
Okay.
Pilot before.
Pardon?
At that.
You
time,
can
bring it at that hearing.
bring it at that hearing with the amount.
Okay.
And then I will go from there.
Okay.
Anything from you guys?
I just need to know where I'm supposed to be next.
We need to set another date, but council, if you'll prepare an order consistent with the court's ruling today, I will set a hearing on damages as well as what will be the court's enforcement of its, the motion for summary disposition. When
How far would you like to go?
No, she's not going to turn herself in. What she's going to do is she's going to contact the court, schedule a hearing, and then show up at that hearing and explain herself, get a fine, and walk out of there without ever going in handcuffs. Mr. Allen might be standing behind her the entire time, but I don't think we're going to see Miss Tope in handcuffs unless she completely ignores this. Then yeah, we might see her in handcuffs. But that's not the biggest news of the evening. The biggest news is, thanks to you all, we got that goal. Thank you everybody that helped Muse get to this. And this wasn't even, you know what? I don't really want to go through the story, but Muse, hopefully you're still here. I know you were here earlier, but the goal has been hit. You all are awesome. Thank you so much. I know that's going to help Muse's family. This is amazing. Like I've said from the start, we take care of our own. Muse has been around for over a year. I trust Muse so much that I made them a mod. So yeah, so this is great news, and thank you all for your help. I do sincerely mean that. This is amazing. Um, yeah, I'm kind of what I feel choked up right now because I have the best community on the internet. You guys are clear. You guys are obviously the best community on the internet. Thank you so much, everybody. With that being said, I'm gonna let the rest of this video play out, and yeah, we got a bench warrant for Mitch Tope. Like I already gave you what I think is gonna happen. Is that gonna happen? I don't know, but that's just what I see. Attorneys don't usually go to jail for things like this. They usually get a fine for contempt of court, but she didn't show up, so does have a bench warrant. But as an attorney, she knows what to do. She, like I said, she can contact the court, schedule a hearing, show up to the hearing. So we might see her within the next. We're probably going to see her this week. It might be tomorrow. I don't know, but Judge Simpson, maybe he'll be done with it. Be like, no, I want her in handcuffs before I see her. That could happen too. We have no idea. But my guess is that she's going to schedule a hearing and show up and say sorry and be out of the handcuffs. She'll probably receive a fine. She'll get sanctioned a fine. That's just my guess. Again, I could be wrong. I'm not an attorney. Anyways, thank you all. You guys are amazing. Thank you so much for helping Muse and Muse's family. Giant, all the love to everyone in this community. I can't say that enough. But I am going to call it a night, and I'm going to go hang out with Heather. I'm going to go tell her the good news that we just hit the goal for Muse. She's going to be really excited about it too. So have a great rest of your evening, everybody. I'll see you tomorrow. The video that I was going to play tonight just got kicked off to tomorrow. I've got a good pro se pre-trial. It's a final pre-trial where, it's the very last hearing. It's a trial readiness hearing where the pro se is just asking just really dumb questions on the eve of trial. Now the trial is actually next week, but he was asking really dumb questions, and the judge just kept saying, "Are you sure you don't want an attorney?" He's like, yeah. To the point where the pro se guy even actually said on the record, "Can I have someone in jail help me with this? I don't want an attorney, but can I have one of my friends in jail help me with this?" It's like, guy, what are you doing? What are you doing? So that case is going to be tomorrow night, unless something else big pops off tomorrow, and I'll just kick it off till Thursday. I don't know, but it's a good one. It's a long one. Otherwise, I would just release it in a video tomorrow. But it's a long one. It's about a 45-minute hearing, so that's going to happen tomorrow. Anyways, you guys are awesome. Thank you so much for hanging out with me tonight. Thank you, mods, for all your hard work, and thank you everyone for helping Muse. You guys are awesome. I'm not spoiling it. It's not. Those aren't spoiled. Those aren't spoilers. Those are just highlights or a summary. Maybe a little bit of spoiler, but you're gonna want to watch it. You're gonna want to watch it. Anyways, you guys are great. Thank you so much. Have a great night, and I will see you tomorrow. Till next time, bye.
So we have the 17th of February or March 3rd.
You don't want to be here the 17th. I'm gonna just tell you, it's gonna be an ugly day.
Yeah.
So I wouldn't do that to you guys.
I'm sorry, what were the dates again?
And my next date is what, March 2nd, March 3rd. 30 days from today.
March 3rd, we're flying back from my.
Pardon?
On March 3rd, we have me flying back and see my mom in Texas.
Possible to get a different date?
Well, it's always possible, but
March 10th.
it would be March 10th. That's a ways out, but I think that's what I'll go with. If those are my options. So I'll
Would you
adjourn.
be able to go Zoom? Well, no, we can't.
We'll be, no, that's the problem. Maybe we can't, mom's 80.
So basically, so that you know it, that's going to be, having granted the motion, that's going to be the court's determination of the eviction date and the money that's owed
March 10th.
on March 10th. (2026) at 9 a.m.
Oh, there's a lot scheduled. There's a lot scheduled. Miss Tope's other clients are going to be there the 17th. There's another case that got pushed back to the 17th. Something that we covered last week as well. The 17th is going to be a crazy day. It is. All right. Anyways, I just wanted to say that you guys are awesome. Okay, bye.
Anything else?
Yes, we need to rate somebody. I just got so excited that we hit the goal that I'm not even thinking straight. Hold on. I'm sorry, guys. How do I do this again? Let's see, live stream, customization, redirect. let's rate Biggin. Biggin's about to be done. We'll rate Biggin tonight. That'll be fun. All right, you guys are awesome. Okay, bye.
No, hearing none. Thank you, folks.